If you live in Florida, you've probably watched a neighbor, friend, or family member face an impossible choice. Pay for nursing home care out of pocket and watch their life savings disappear, or go without the care they desperately need. But what if I told you there's a third option? One that lets you protect your home and savings while still getting quality care when you need it. Hi, I'm Chuck Roulet. I'm an estate and elder law attorney licensed in both Florida and Minnesota, and I have nearly 30 years of experience helping families just like yours. And today I'm going to walk you through exactly how long-term care planning works in Florida, what it costs, and most importantly, how you can protect everything you've worked for. But first, if you haven't already, make sure to click the like and subscribe button so you'll be notified when I post new videos like this one, and to share it with friends and family members that may need the information. If you have a question, post it in the comments below and I may answer it in an upcoming video. And if you stay until the end, I'll share some resources where you can discover more. Now let me tell you about Mary and John. They're a couple I worked with right here in Venice. Mary needed nursing home care after a stroke. John thought their estate plan was solid. They had a will, they owned their home outright, and they had about $400,000 in savings. But here's what shocked them. The nursing home cost $12,000 a month. That's $144,000 a year. And at that rate, their entire life savings would be gone in less than 3 years. And John would be left with almost nothing. And they asked me, Chuck, why didn't anyone tell us about this before? And that's exactly why I'm making this video. Because most people don't realize that a single nursing home stay can wipe out decades of hard work and careful savings. So let's talk numbers. In Sarasota and Manatee counties, nursing home care can easily run $10,000 to $15,000 or more per month. And that's depending on the facility and level of care. And that's not a typo. We're talking about costs that can reach $180,000 or more per year. Now, here's what many people don't know. Medicaid can help pay for this care, but there's a catch. Well, actually, several catches. First, to qualify for Medicaid in Florida in 2025, you need to meet strict limits. Your income must be under $2,900 a month. You can only have $2,000 in countable assets, and Florida looks back 5 years at any assets you've given away or transferred. And here's the kicker. Just because you qualify for Medicaid doesn't mean your dream facility will accept it. So how do you protect your home and savings while still planning for care? Well, that's where smart legal planning comes in. So let me tell you about another couple, Bob and Susan. They came to see me when they were both in their late 60s. They were healthy, active, and enjoying retirement here in Sarasota. And they wanted to make sure that if one of them needed care down the road, the other wouldn't be left broke. So here's what we did. First, we set up a Medicaid-compliant irrevocable trust. Now, I know that sounds complicated, but think of it this way. It's like putting a fence around your assets that protects them from nursing home costs while still following all of Florida's rules. The key is timing. Remember that 5-year look-back period? That means if you transfer assets to family or friends within 5 years of applying for Medicaid, you'll face penalties. But when you use the right legal tools, like properly structured trusts, you can protect your savings legally and avoid these penalties entirely. We also set up qualified income trusts, also known as Miller trusts, so that they could still qualify for benefits even if their monthly income was too high. We also set up contracts with their kids so they could be paid for assistance they provided to their parents as they aged. We also updated their power of attorney and healthcare documents. Why? Well, because if Bob or Susan couldn't make decisions for themselves, these documents would let the other spouse and their kids handle everything without going to court. No delays, no stress, no expensive legal battles. Now, you might be thinking, well, this sounds great, Chuck, but when should I actually do this? So here's my advice after working with hundreds of families. While you're in your 60s, this is the perfect time. You're still healthy, you have options, and you can put protections in place that will mature over time. Remember that 5-year look back? If you plan in your 60s, by the time you're in your 70s, your assets are protected. When you're in your 70s, you still have time, but you need to act more quickly. You should also review your plan every few years, update your documents after major life changes, and start researching care facilities so you're not making rushed decisions later. When care is needed now, well, even in a crisis, there are strategies we can use. Things like qualified income trusts can help if your income is slightly too high for Medicaid. But I'll be honest, you have fewer options when you're in crisis mode. That's why planning ahead is so important. So let's talk quickly about choosing the right facility. This is one of the most emotional decisions you'll ever make. When you visit facilities in Venice or Sarasota, ask these critical questions. Do you accept Medicaid and are there wait lists? What happens when we transition from private pay to Medicaid? Are there extra charges for therapy or personal care? What protections do you have against involuntary discharge? I've seen families choose a beautiful facility only to discover 6 months later that it doesn't accept Medicaid. By then, they've spent down their savings and have to move their loved one to a different facility. And that's heartbreaking and completely avoidable with proper planning. Now, before we wrap up, let me share the 3 biggest mistakes I see families make. First, mistake number 1 is giving away assets to children or relatives without legal advice. This triggers that 5-year look back and creates penalties. Mistake number 2 is assuming their regular estate plan protects them from nursing home costs. A will or even a revocable trust won't help you qualify for Medicaid. Mistake number 3, waiting until there's a crisis. The best time to plan was 10 years ago. The second best time is right now. Look, I get it. This stuff is complicated. It's overwhelming, and it's not exactly fun to think about. But here's what I know after nearly 30 years of doing this work. Families who plan ahead sleep better at night. They have options. They protect their spouse. They leave something behind for their kids instead of losing everything to nursing home bills. So here's what I'd like you to do next. First, visit our website at roulettelaw.com to learn more and schedule a consultation. We'll sit down together and create a customized plan that protects your specific situation. So whether you're in Venice, Sarasota, or anywhere along Florida's Gulf Coast. Second, I want to give you a copy of my guide, Save Our Home: How to Protect Your Home and Life Savings from Long-Term Care and Nursing Home Costs. It's packed with information that can help you start planning today. Just click the link in the description below to download your copy. And finally, if you want to discover more, join us in my upcoming exclusive Masterclass, where I'll reveal the strategies I use with my private clients to help them protect their home and savings from nursing home and long-term care costs. And you can sign up by clicking the link in the description below. Remember, you worked too hard for too many years to lose everything to nursing home costs. And with the right plan, you don't have to. Thanks for watching. I hope you found this video helpful, and I look forward to seeing you in an upcoming video or the Masterclass. Be well.